Right in the
Probably 4:45 is what we're thinking. I'm hoping we should get through it. The Subcommittee on Courts and Intellectual Property and the Internet will come to order. Without objection, the Chair is authorized to declare a recess of the subcommittee at any time. We welcome everyone here today for a hearing on H.R. 1057, the Promoting Automotive Repair, Trade and Sales Act of 2016, otherwise known as the Parts Act. I'll now recognize myself for an opening statement. This afternoon's hearing is about an important piece of pro-consumer legislation, the Parts Act. It is narrowly focused and designed to once and for all call appropriately attention to the use of ornamental patents for broader than their original purpose. For a great many years, patents, known as design patents, were clearly understood to be ornamental, meaning if someone were to duplicate the appearance of a patented product, they would be violating that look for a period of 14 years. Under the Parts Act, this is a limited bill. It relates only to car parts that are typically replaced after collision, and it allows a limited exemption to the design patents so the aftermarket parts of like use of form, fit, and quality can be available for basic repairs. This does not mean that marginal or low quality parts are by definition to be considered as acceptable. In no way, shape, or form is this about the quality. As we all know, and we know too well, automobile companies around the world have made magnificent automobiles. They also made the Pinto, the Vega, the Yugo, the Lada, and I need not go on to tell you there have been cars that have been shoddy in their manufacture, unreliable, and yes, I have visited the Corvair Museum. There are cars with other notability. But in this case, we are simply creating a balance between the rights of the manufacturer to produce an ornamental design and protect it for a period of 14 years from its competitors, people who would produce a similar automobile look. That's the intent of a design patent. It was never intended to be, in fact, a substitute for the ability to simply repair a portion of something you have purchased. Now let's understand, the automobile industry is unique. They do create rolling pieces of art. Those rolling pieces of art should, in fact, enjoy their distinctive advantage. However, it is notable that it is very seldom does General Motors sue Toyota, Toyota sue Honda, or any of them sue Mercedes when they make cars that are so close together that even their commercials find it hard to find the automobile that matches. They make fun of how similar cars look, and yet you don't see automobile patent suits related to the design patents, meaning the auto companies do not consider there to be a great value to the design patents when they are looking at similar designs between automobile companies. Having said that, the very lucrative auto aftermarket business related to collision parts is an area in which the auto companies have attempted to establish greater and greater exclusivity. And I support that exclusivity, but for a limited period of time. The Parts Act is intended, recognizing that an automobile exceeds $30,000, and one would spend 3 or 4 times that if you were to buy it in parts from the manufacturer, that in fact, instead of pounding out a fender, welding or bondoing it, a affordable replacement in a competitive market is in the best interest of safety and, of course, the consumer. Additionally, a healthy aftermarket means more affordable parts for everyone, and particularly in the case of small production or out-of-date, older automobiles or automobiles that are no longer produced, such as the Saturn or the DeLorean, or for that matter, the '65 Mustang. These parts, without the Parts Act, if a healthy aftermarket industry does not exist, will not and are not typically made at an affordable price by the manufacturer. Manufacturers do not want to have a lifetime responsibility to keep a set of tooling to make a part. If they did, certainly they would be a desirable place for the classic car repair business. People in Europe already enjoy some of the considerations that are in the Parts Act, and for a good reason. The consumer has an expectation that it is, and a reasonable expectation, that there will be a competitive market for repair parts for their automobile. There certainly is for brake pads. Why wouldn't there be for a bent fender? I look forward to working with people on both sides of the aisle and on both sides of this issue to ensure we make the kind of limited, narrow, and appropriate changes to the patent law to allow automobiles to be repaired while in fact protecting the intellectual property of the auto manufacturer or any other original equipment producer now or in the future. I look forward to our witnesses today, and I look forward to working with the chairman and ranking member on this area as we move forward with the Parts Act and it gets signed into law. I now would like to recognize the ranking member of the subcommittee, Mr. You want to go next, right? Yeah. Mr. Nadler from New York for his opening statement.
Thank you, Mr. Chairman. Today we consider H.R. 1057, the Promoting Automotive Repair, Trade, and Sales, or Parts Act of 2015. This legislation, introduced by Chairman Issa and the gentlewoman from California, Ms. Lofgren, would reduce the term of design patent protection for exterior automotive repair parts like fenders, side view mirrors, and headlights from 14 years to 2.5 years. Supporters see it as a pro-consumer bill to foster much-needed competition in the collision repair parts market. But opponents see it as an unfair exemption to establish patent law at the expense of one industry with potential safety implications. Each side makes compelling arguments, and I appreciate the opportunity to examine these issues in greater detail today. According to supporters of the Parts Act, thousands of consumers each year pay artificially inflated prices for car repairs because auto manufacturers control more than 70% of the market for repair parts. To make matters worse, they say, manufacturers have recently begun to enforce their design patents against generic parts makers, threatening to eliminate whatever competition currently exists for aftermarket parts. Without the Parts Act, they argue, consumers could see already high prices soar even higher as the generic market shrinks and automakers seize a near monopoly on repair parts. These consumers see a market with little competition and wonder why there is a thriving market for generic drugs, but not for generic taillights. According to some estimates, since generic auto parts can cost up to 50% less than brand name alternatives, consumers would pay over $1 billion a year more for repair parts if the independent market were to be eliminated altogether. And if repair parts cost more, insurance companies will be forced to raise their rates too, further hurting consumers. The Parts Act would provide automakers 30 months of design patent protection for aftermarket products. Long enough, supporters argue, for automakers to receive a healthy return on investment, but not so long that it would stifle the competitive market for repair products that consumers deserve. And car companies would still retain a full 14 years of protection against other automakers that might seek to copy their designs on new cars, since the bill only applies to repair parts. But this begs the question, why single out only one industry for weaker patent protection? Opponents of the Parts Act believe it would set a dangerous precedent in intellectual property law. They fear a slippery slope in which more and more industries are carved out for special treatment under the patent system, leading to a system that is both incoherent and unfair. How should we draw the lines between which industries are deserving of full protection, full 14-year protection, and which are not? We may not always appreciate the aesthetic design of a car's component parts, but automakers invest significant resources to design every aspect of their products so that they stand out to potential buyers. Opponents of the Parts Act argue that it would be unfair to deprive these manufacturers of the full return on their investment. They also note that auto manufacturers employ nearly 30,000 people in the U.S. in design centers. We risk losing some of these jobs if we reduce the incentives for automakers to create their innovative designs. Opponents further warn that the bill could threaten the safety of unsuspecting consumers who purchase a generic repair part which may be of lower quality than its brand name equivalent. If a generic bumper looks identical but provides insufficient protection in an accident, it is certainly no substitute. As we examine the Parts Act, we should consider whether additional safeguards ought to be put into place to protect consumers from shoddy parts before encouraging a significantly larger market for such generic products. Today's hearing, hopefully, will help us to determine the answers to these and other important questions as we examine the proper balance between respecting the rights of creators and ensuring that customers enter a safe, competitive marketplace. We have an excellent set of witnesses to help us sort through these issues, and I look forward to their testimony. I yield back the balance of my time.
I thank the gentleman. We now go to the gentleman from Michigan, the home of most but not automobiles.
All the big three.
Oh, yeah, but Cleveland rocks. Thank you, Mr. Chairman.
Thank
Now
you.
recognize the gentleman from Michigan.
Thank you so much, Mr. Chairman. Members of the committee, this bill would create an exception for certain automotive parts from patent protection. And so we should review the bill's impact on patent law, but also on consumers. To begin with, we should consider whether the exception in this bill to design patent law undermines our intellectual property system. Intellectual property protection is a cornerstone of our economy. This legislation, however, creates an exception for design patents and could arguably weaken our patent system. It could foster the importation and sale of unauthorized copies of patent-protected vehicle parts. Automotive companies make significant investments in the development of new exterior automotive parts. Then they acquire a design patent so other companies cannot use these designs without their approval. Our patent system protects the patent holder as it should. Now, if Congress is going to legislate a carve-out in patent law, the reasons for it should be exceptional. Supporters of this legislation contend that Congress needs to create an exception because the cost of replacement parts offered by car companies is too expensive. They argued that lower prices would benefit consumers who need to make repairs to their vehicles. But automotive manufacturers may raise prices on new cars to replace lost revenue of parts that would otherwise infringe their design patents are allowed on the trade market. This will hit consumers' pocketbooks when they go to purchase new cars and trucks, and it will hurt car companies who are still getting back on their feet. We've heard this cost argument in other situations, but if we weaken the patent system by creating an exception, we'll be weakening the incentive for companies in every industry to be innovative and to bring new products to market. Finally, we must consider how the bill would impact consumer safety. I'm concerned that off-brand parts in general may be less safe than those provided by car companies because there are no federal regulations requiring minimum safety standards for off-brand parts. In fact, the vast majority of these parts are never subject to inspection by third-party testing organizations. Without federal minimum safety standards on the quality of non-original replacement parts, consumers' safety may be at risk. Consumers already have a difficult time telling the difference between a quality part and an inferior or even dangerous one. An exception to patent protection, as proposed by the measure under examination this afternoon, could make this problem worse. While a part protected by a design patent is not necessarily a guarantee of quality, the fact is that if car companies churn out inferior or defective parts, they are ultimately held accountable. I am sympathetic to the consumer cost concerns that supporters of this bill are raising today, but I am not yet convinced that such an exception will bring forth the benefits they claim will come. While there's no guarantee that the insurance companies will pass savings on to consumers, what is guaranteed is that if this bill passes, there will be more unregulated, untested car parts on the market, and we will see many more groups seeking exceptions to our patent laws. And for these reasons, I come to this hearing skeptical of creating an exception in our design patent laws as envisioned by the measure before us today. And I thank the chairman and yield back.
I thank the gentleman. I now ask unanimous consent that the chairman of the full committee, Chairman Goodlatte's opening statement be placed in the record. Without objection, so ordered. Without objection, other members' opening statements will be made a part of the record. Today we have a distinguished panel before us. 2 witnesses for the bill, 2 witnesses who are skeptical, as the ranking member said. The witnesses' opening statements, written statements, have been entered into the record in its entirety, and I ask, please, for you each to summarize in approximately 5 minutes. If you can stay within the time, it will allow us not only to get through your opening statements, but through a robust set of questions from this side of the dais, and still adjourn before our votes, which will come sometime, probably shortly after 5. Before I introduce the witnesses and pursuant to the committee's rule, would all 4 of you please rise to take the oath? And please raise your right hands. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Please be seated. Let the record reflect that all witnesses answered in the affirmative. Our witnesses today include Mr. Jack Gillis, Director of Public Affairs for Consumer Federation of America, Ms. Kelly Burris, Intellectual Property Attorney and owner of Burris Law Firm, PLLC, Ms. Pat Felder, owner and founder of Felder's Collision Parts, and which city in Louisiana, ma'am? Baton Rouge. I love to just say that. That's such a pretty city. And Mr. Dan Risley, President of the Automotive Service Association. Again, your entire written statements will be placed in the record. And Mr. Gillis, you're first up. I'm afraid, Mr. Gillis, for the record, if you could either turn on your mic or pull it closer or both.
It was off.
Thank you.
In addition to representing the Consumer Federation, I am also representing the Advocates for Highway and Auto Safety, the Center for Auto Safety, Consumers Union, which is the policy and research arm of Consumer Reports, and Public Citizen. We are extremely grateful for your invitation to appear today. I'd like you to consider any of the following experiences which happen every day. You back into a pole, you sideswipe your car, and fortunately these fender benders generally do not result in injuries, but they do result in shocking repair costs. Why does a fender bender have to cost $2,000 to $3,000 to get your car fixed? Well, one reason is the cost of the parts that we need to get our cars repaired. For example, Ford charges the same price for a fender as Dell charges for a computer and a flat screen monitor. An unpainted door from Toyota costs the same as a Sears refrigerator, and that refrigerator comes with 2 doors already painted and already installed. In fact, a variety of products are cheaper and better today thanks to one thing: competition. In the early 1990s, the car companies asked Congress for special design copyright patent protection on these replacement parts, and Congress said no. Blatantly ignoring Congress's admonition, there has been an enormous spike in the number of design patents by companies like Honda, Toyota, and Ford. For these companies to come before you today and say that suddenly these parts are patentable, when for years and years they were not, is both disingenuous and extraordinarily costly for the American consumer. This is a newfound business strategy, not a legitimate use of U.S. patents. The competition that the car companies are trying to kill lowers prices, provides choice, and improves quality. When we plunk down our hard-earned dollars for a new car, we are buying a car, not a lifetime of indenture to the car companies to buy their brand of parts. Regarding the safety of these parts, the very organization cited by the car companies, the Insurance Institute for Highway Safety, did address this issue and determined in both low-speed damage tests and high-speed crash safety tests that alternative parts, CAPA certified to be the same, in fact performed nearly identically. I've been fighting for safer cars for over 35 years, and I find it bizarre that the car companies are coming before this committee to allege that their illicit use of design patents is for safety reasons. This very Congress has caught these car companies red-handed, foisting unsafe airbags, ignition switches, and other defects on their very own customers. In fact, in addition to cheating on fuel economy standards, for the last 2 years, about 3 times as many cars have been recalled as have been actually sold. The most tragic irony of the lack of competition is what I call the automakers' double whammy. Not only can the car companies charge whatever they want for the parts that we need to fix our cars, but when they charge so much that the car is totaled, our only recourse is to go back to them and buy another one of their products. Imagine that business model. And here's the icing on the cake. In spite of all their admonitions against competitive parts, Ford, GM, and Chrysler have all entered into special agreements specifically allowing independent manufacturers to make their patented parts with no oversight or specifications. Aren't these the very parts that they are railing against? Nevertheless, because of these patents, they are getting royalties for the manufacturer of the very parts they are telling this committee shouldn't exist. That, to me, is the height of hypocrisy. So we applaud Representatives Issa and Lofgren for introducing H.R. 1057. It is a step forward in protecting the American consumer from being forced to pay unfair prices to fix our own cars, while still enabling the car companies to retain the design patent protection on the overall vehicle. So on behalf of the Consumer Federation of America, the Advocates for Highway and Auto Safety, the Center for Auto Safety, Consumers Union, and Public Citizen, I strongly urge Congress to adopt the repair clause to the design patent law. And we thank you very much for providing us with the opportunity to discuss this issue with you today.
Thank you, Ms. Burris.
Good afternoon, Chairman Issa, Ranking Member Nadler, and distinguished members of the subcommittee. Thank you for the opportunity to be here today to share my views on another version of the Parts Act of 2015, on none other than Groundhog's Day. I can't be the only one that noticed that, right? So I have serious concerns with the legislation and the impact it would have in 3 primary areas. First of all is jobs, good, high-paying, white-collar jobs. Second, as we've all been discussing, the safety and the quality of the vehicles. And third, more important to me, is the impact it would have on our legal system, and more specifically, the degradation of our patent system. So jobs, briefly, which was set forth in more detail in my written statement, in the United States, this is a hub for industrial designers in the United States for automotive vehicle design. You have 15 OEMs with 21 design centers in the United States, in Michigan, in Ohio, and in California. Those design centers employ roughly 30,000 industrial designers, and there's to the tune of billions of dollars being spent in the United States on the look of that car, something that's eye-pleasing to the consumers. And so this is a hub for industrial designers here in the United States. And at a time when we are pushing STEM education to our youth, I just find it odd that we're pushing students to go that direction, but yet devaluing what it is that an industrial designer produces as a result of their engineering efforts. So number 2 is the safety and quality, which we'll, I know, talk about more. And one of the things I don't think we've really fleshed out a lot is we're not looking at these parts in a vacuum. These parts, these exterior parts of the vehicle, are part of an overall system. And as the automotive manufacturers are putting collision avoidance technology into the vehicles, lane avoidance, lane detection, there are sensors all over the car. And are we looking at the interaction between those sensors and the exterior parts? And what if you replace a part that doesn't have the same quality standards? Will it function the same with the rest of the system? And as we move towards autonomous vehicles, I think that situation gets a little more intense. So that's something I think we should have a conversation around. Third, and more important to me as a patent attorney, is, okay, so we carve out this exception for repair parts, what's next? I drop my smartphone on the floor, I have to get it repaired, it's too expensive. Do we go to Apple and Samsung and say, hey guys, guess what? We're going to take away your design patents too, because they have many more design patents, and I would love to look at a curve of what their design patents look like in that industry, especially after the Apple-Samsung case. Secondly, I think the practical impact of the 30 months is really amounts to much less than 30 months, if any term whatsoever, because it's from the date of the offer for sale. And automotive manufacturers, any design patent applicant does not have that design patent in hand as soon as they go launch their product at an auto show, at a trade show, off to the consumers. So by the time a consumer gets in a car and hits the road, I don't think you're going to see any patent term at all. So that 2.5 years doesn't, it's not 2.5 years from a practical standpoint. The language of the bill also talks about motor vehicles. It's not automobiles. We're talking about motorcycles, scooters, farm equipment. If you look at Caterpillar, Harley-Davidson, they own hundreds of design patents themselves. So this is reaching into other industries besides automotive. So that's another concern that I have. And I know that there's been discussions about this type of legislation being enacted in Australia and also in Europe, but I haven't seen any facts to show what impact that's having in those countries. And I'll also note that the deliberations in the European Union are talking about making sure that those parts are being marked and that there's compensation to the original design patent owner. So I will stop my remarks there, and I thank you for your time and look forward to our discussions today.
Thank you, and I will mention that I had to get on 3 airplanes, one after another, and get off of them before I finally got on a plane that brought me here. So I feel Groundhog is with us. Ms. Felder.
Chairman Issa and Ranking Member Nadler, and members of the subcommittee, I am Pat Felder. My husband and I own Felder's Collision Parts in Baton Rouge, Louisiana. Felder's is a small business which has been making quality, lower-cost aftermarket collision repair parts available in the marketplace since 1987. At the outset, I would also like to thank Chairman Issa and Representative Lofgren for their bipartisan leadership in sponsoring the Parts Act, as well as the other House Judiciary Committee co-sponsors of this bill. I am testifying on behalf of all of the independent aftermarket distributors throughout the country who have, like Felder's, been on the front lines of the car company's efforts to eliminate competition through design patent enforcement. It has been a gut-wrenching experience having to lay off good, long-term employees who are all like family. To help frame this issue, if you have ever been in a fender bender and at that time you had your car repaired, you have benefited from competition in the collision repair parts marketplace, whether you knew it or not. This competition has existed for decades between the car companies and the aftermarket industry. The collision repair parts to which I am referring are cosmetic in nature, the exterior parts of a car, such as a fender, a hood, or a grille. Generally speaking, these parts are not structural or safety-related parts. The purpose of these parts is to restore the vehicle's original pre-accident appearance. These are must-match parts that leave no room for innovation by alternative suppliers. The car company currently have 2/3 of the collision repair market, while alternative suppliers have about 14%, with salvage making up the difference. Despite our relatively small market share, the competition that we provide is important because alternatively supplied collision repair parts typically are 26 to 50% less expensive than the car company parts. But even if a consumer uses a more expensive car company part, the competitive marketplace has caused car companies to lower their collision part prices. The estimated total benefit to consumers from the availability of alternative parts is approximately $1.5 billion per year. Despite the benefit of competition, Some car companies are seeking to eliminate competition and expand their dominant share of the market by obtaining 14-year design patents on their collision parts and enforcing them against alternative suppliers. In 2005 and 2008, Ford filed design patent infringement complaints at the International Trade Commission against aftermarket suppliers of collision repair parts for the F-150 pickup truck and Mustang, respectively. Ultimately, these suits resulted in an exclusive settlement by which one of the aftermarket competitors must pay a royalty to Ford for every Ford aftermarket part it sells, a cost that will be passed along to the consumer. And for all of the aftermarket suppliers, like Felder's, who are not part of this exclusive settlement with Ford, we are at risk of design patent infringement suits if we continue to sell these parts, as we have done in the past. As a result, Ford effectively created a duopoly, diminishing competition in the repair parts marketplace for owners of Fords. Since that time, Chrysler and General Motors have followed Ford's lead. The impact of eliminating competition in the collision repair market falls directly on consumers in several ways. $1.5 billion would be added to insured automobile repair costs every year, resulting in higher premiums. Consumers paying out of pocket might choose to forego repairs, and higher repair costs may increase the likelihood of a vehicle being declared a total loss. The impact would be much greater on those of low-income or fixed-income consumers who can least afford it. Moreover, the average consumer keeps their vehicle for 11 or more years, and it depends on a competitive repair marketplace, not only for the affordable quality repairs, but also to the extent that the car companies no longer can sell these certain, or do sell these certain collision parts. We are not here today to advocate for the use of one part over another. We believe that the Parts Act will preserve competition in the market for collision repair parts and benefit consumers by helping to keep the cost of car ownership as low as possible. Thank you.
Thank you. Mr. Risley.
Good afternoon, Mr. Chairman and members of the subcommittee. My name is Dan Risley. I'm the
We're going to need it just a little closer to the microphone. Thank you.
My name is Dan Risley. I'm the president of the Automotive Service Association, and I am here today representing our association. ASA is the largest not-for-profit trade association of its kind, dedicated to and governed by automotive service and collision repair professionals. ASA serves an international membership base that includes numerous affiliate, state, and chapter groups from both the collision and mechanical repair segments of the automotive service industry. Prior to ASA, I worked at a family-owned collision repair facility, served as the executive director of another automotive association, as well as spent a number of years at Allstate Insurance Company. ASA has a long history of working with insurance companies and ensuring our customers the best possible repair experience after an accident. ASA is supportive of insurer direct repair programs, provided the vehicle owner has a choice and is properly informed of it. Many of our leaders serve on direct repair program advisory boards of state and national insurance companies, including myself. Many years ago, I participated on a top 3 insurance carriers advisory panel. Although we work closely with insurers, we are mindful that our customers' vehicles are our first priority, and that these vehicles must be safely and properly repaired. We do have concerns when some insurers insist on repairs that are simply cheaper and quicker without regard to quality and safety. This is not to imply that all insurance carriers are the same. There's a difference between standard and non-standard. That is why my board of directors, made up of repair shop owners from across the U.S., wanted me to testify here today before you. The automobile is the second most expensive purchase made by Americans. Although the automobile is a major part of most Americans' daily lives, few vehicle owners know much about collision repair. After an accident, other than contacting law enforcement or other emergency personnel, the vehicle owner contacts their insurance company for help and direction. Unfortunately, very few consumers have any knowledge about the types of crash parts used to repair their vehicles, and there are numerous parts choices in the marketplace, such as original equipment manufacturer parts, certified and non-certified aftermarket parts, remanufactured, and recycled. The fundamental language used in this bill would systematically validate any and all aftermarket parts to be the equivalent of an OEM part. In Section 2 of the bill it states, so as to restore such vehicle to its appearance as originally manufactured. This is impossible. Unless, of course, there's a standard by which all the aftermarket parts companies are required to meet. We have several standard-setting part certifiers in the marketplace today, CAPA being another one and NSF being another. And it is supported and endorsed, recognized by the industry, both collision and insurers. CAPA was created in the 80s because there was no standard, there were no requirements, no monitoring of aftermarket parts. It was the equivalent of the Wild Wild West. Having worked in a family-owned collision repair facility, I can assure you that we ordered and I personally installed many parts in the early 80s when CAPA did not exist. These parts that were deemed to be OEM equivalent were later deemed to be inferior in terms of fit and function. Although an aftermarket part looks the same as an OEM, it does not mean it's the equivalent of an OEM quality part. It does not mean that the part has the same corrosion resistance, metallurgical properties, or that it will perform the same in a subsequent accident, similar to how an OEM would perform. Certification helps to eliminate or narrow those gaps. Although part certification is not perfect, it does positively impact parts quality. I spent several years chairing a committee working with the Taiwanese aftermarket parts manufacturers as well as their government. One of their biggest challenges for the Taiwanese was the U.S. marketplace and balancing the cost versus quality. The fact is, certified parts do cost more to produce. Certification not only is important but critical to this debate. Under the current language in H.R. 1057, providing a faster, less expensive path for aftermarket crash parts manufacturers to put non-certified parts in the marketplace will harm both consumers and small business. It has been proven through many years of collision repair's trial and error that the vast majority of non-certified parts are inferior in many aspects, not only to the OEM, but also to the equivalent certified aftermarket part. Aftermarket crash parts manufacturers will manufacture parts to achieve the lowest cost in an effort to sell the parts inexpensively to distributors in the U.S. demanding a low-cost basis. I have personally witnessed aftermarket parts, non-certified, that did not have holes where there were supposed to be holes to fasten it to the vehicle. I have personally witnessed parts that have additional holes where there wasn't supposed to be any to fasten it to the vehicle. I've witnessed parts that were not of the same metallurgical thickness, parts that were significantly lighter and prone to dent, missing brackets, missing headlamp parts, wrong color, improper reflective properties. When parts don't fit or there are other issues, collision shops have to return the parts to the distributor. These returns add cost to the collision repair process as well as delay the repair. Whether it's legislation being discussed today or mandates that insurers place on collision repair parts facilities such as Aware Buy Parts, insurers will argue that these initiatives lower premium costs. We don't see where these part savings are passed on to consumers. It's a good soundbite, but the consumer will continue to be the loser in this equation. I want to leave you with a few key points. Number one, a free and open marketplace does not entail enacting a law that states aftermarket parts are equal to OEM. This should be decided by the people actually purchasing the parts. Competition is good. There is a need for alternative parts such as certified aftermarket parts, recycled, remanufactured, used. Legislating competition so that company X and Y are equal is similar to legislating that Walmart shirts are similar to something you might see at Macy's just because it looked the same online in a picture. You may hear, I've heard testimony here today about these parts being about them being cosmetic. I can assure you a hood is not a cosmetic part. A hood is designed to crumple. In the event that the hood should fail to crumble, the hood is going to be pushed into the windshield, into the occupants. If it does not fold like an accordion, I'm going to close it up. We ask the committee to consider the implication this legislation will have on the consumer and small business. We ask the subcommittee to oppose the PARTS Act. I appreciate the opportunity to testify before the committee today, and thank you very much for your time.
I thank you. We have a number of members that have to go to the floor. So what I'm going to do is I'm going to take the liberty of, without objection, calling on members that must leave for the floor out of order If anyone objects, please let me know. Otherwise, I'm going to try to accommodate members that I know have to leave. With that, I will go to my ranking member, Mr. Nadler, first.
Thank you, and I appreciate this. I do have to go to the floor to debate an amendment shortly. Mr. Gillis, what is the rationale for singling out just the auto parts industry for special treatment under the patent laws? And do you worry about the precedent that this bill would set by limiting patent protection for one narrow category of items?
Yes, that's a possibility. I think that overall, there are probably a number of industry areas that could use this type of repair
But what's the
clause
rationale for
protection.
singling out this industry?
Well, at this point, right now, it's one of the most expensive items that consumers experience on a day-to-day basis. When you back into a poll and it costs you $3,000 or $4,000,
It's very expensive. That's a rationale.
That's
Any
a
other rationales?
Expense is the key rationale.
Okay. And why now? Why not 20 years ago? Or, I mean, why are we seeing this now?
Well, 20 years ago, the car companies came before Congress, and Congress said no. So thankfully to Representative Issa and Representative Lofgren, we've raised this issue again.
But they haven't changed. In other words, I thought you said that there was a change recently.
Yes. As you see from that chart over there, there's an exponential increase in the number of parts that are being designed patent by the
There's
car
a
companies.
change in the behavior of the auto companies in exercising these patents.
Exactly.
And what sort of protections are in place or should be in place to ensure the quality and safety of generic repair parts?
Well, first and foremost, the parts should be certified to be functionally equivalent to the car company brand part.
Certified by whom?
Well, there's at least one agency that I'm familiar with called the Certified Automotive Parts Association. It's been around since 1987, and in the interest of full disclosure, I'm the executive director of that nonprofit group.
Thank you. Mr. Burris, Ms. Burris, I'm sorry. We've heard about the potential threat to safety that generic repair parts may pose. Can you point to any studies that document that there are, in fact, such risks?
Well, I believe there were some studies pointed out in the written statement that I submitted. I've also gathered information from the automotive companies that, for example, a bumper and the material that it's made out of is designed to absorb energy from a crash. And in one specific instance, there was a design with, I believe, some continuous glass fibers in the bumper.
That's one specific.
Yeah.
Is there data to show that generic parts are involved in accidents at a greater rate than parts made by the manufacturers?
Yes.
There is. And you
Yes, and as a matter of, there are reports in my written statement, and I would be glad to follow up with additional reports.
Okay, and according to estimates referred today, auto manufacturers control more than 70% of the market for repair parts. If the industry continues to enforce its design patents against generic parts, it could achieve a near monopoly. Without competition, how can consumers be sure they're receiving a fair price for these products if we're not to pass this bill?
Well, there are options for the consumers. The consumers can use refurbished parts. They can repair the parts. There are a lot of technologies you can use to repair. You can also make the design look different.
All right, let me ask one last question. Under current law, design patents on auto repair parts receive 14 years of protection against infringement. Most consumers do not own their cars for that long. Doesn't this effectively provide car companies a lifetime protection against competition for repair parts in most instances? And if this bill, if 30 months is too short, I think somebody said 30 months is too, I think you said it
Yes.
doesn't go into effect right away. Is there some other period greater than 30 months but less than 14 years that might be a fair solution? And how would you determine that?
Well, my concern with reducing it to any term below 14 years is what other exceptions are going to be made for other industries. That's what I worry about.
I understand that generic argument. I made it myself. But talking about design patents, one argument you made was that, I mean, there are two things here. One, people don't own cars for 14 years, and that would seem to argue against the 14-year patent. And two, you said that, I shouldn't say nobody owns a car for 14 years. My father did, but most people don't.
Yeah, I do.
But that's number one. And number two, you pointed out that under this bill, it doesn't go into effect right away. That is, 30 months start
It's
after.
retroactive.
Okay. Would there be a different period that longer than 30 months but under 14 years that might be a more fair resolution?
Yeah, I think that's a question that the automotive companies should try to answer. From a legal policy standpoint, I would not, I don't, again, I worry about what that would do in other areas, so.
So your major argument is uniformity of the patent law?
Pardon me?
Your basic argument is uniformity across different areas of the patent law.
Right, because as soon as you make an exception, right?
Got it. Thank you. Thank the chairman for allowing me to question out of order.
I very much thank you for your comments and input. At this time, I'd like to ask unanimous consent the following documents be placed in the record. A statement by Robert L. Lyon, President and CEO of Rockingham Group and others. Without objection, so ordered. A second document, aftermarket shock, the high cost of auto parts protectionism, by Brian Garst of 2016. Without objection, so ordered. Additionally, I'll ask that design patent number 352685, dated 1994, and design patent 345317, March 22nd of 1994, be placed in the record, and I will note I was the designer of those and may just choose to ask questions on that. And with that, I'd like to go to Mr. Collins, who also has to go to the floor.
And I do appreciate the chairman. It is always good to be with the chairman. He and I have, this committee, I think, is really hitting on one of the biggest parts. But I'll also note that the patents that just got admitted into by unanimous consent also were good for 14 years. So that is an aspect which is good and which it needs to be. I think there's some aspects about this bill that are good. There's some aspects that need to be discussed, but there's also some very disturbing, questions. Ms. Burris, you brought up some. Mr. Gillis, we're going to get to some. The heart of this, though, and I want to get back to this, and Ms. Burris, I'll just start with you. If you take the premise of the bill is correct, okay, which I have no doubt the authors, in looking at it, and I think there's some ways that we can work together. I have some specific concerns about language in the bill, but I think there's some possibilities we can work on. The premise of the bill is, do consumers lack affordable options in the marketplace due in full to ornamental design patent protection? If you take the premise of the bill, that's what the premise of the bill basically is, because we've heard about it already. It's money. Mr. Gillis just said that. Mm-hmm. So is that true?
No, it's not true. The consumers have choices. They can go with refurbished parts, remanufactured parts. They can repair the parts. And, from my perspective as a patent attorney, they just need to make it look a little different, and then they won't be infringing the design patent. It's not that tough.
No, it's not. I think, well, take that a step further. And even if the cost differential is the parts is different, there is no evidence that consumers directly would save money if this bill was enacted.
That's correct. The last hearing that we had, I believe the testimony was that consumers' insurance premiums would not go down.
Okay. And I think, Mr. Gillis, I would think you would disagree, but is there hard and fast evidence that consumers will save money post-enactment of this legislation?
Absolutely. When you look at the comparative cost of an OEM part to an aftermarket part, it's phenomenally different. And that is what consumers pay for if they're crashing the car themselves and paying for it themselves, or it's being incorporated into their insurance premiums.
Okay, and I think you take a major leap of faith there, which I'm a man of faith, so I'll go with your leap of faith. I could understand that if I was buying it myself, like my Honda has a broke front end right now, zip ties work wonderful. But if I did it myself, then I might there could save money there. But if I depend on the insurance company to pass their savings along to me, can you honestly sit here under oath and say that I'm going to see savings from my insurance company?
Well, I think you're already seeing those savings because most insurance companies do already use aftermarket parts.
Exactly, but you are extrapolating there. If this bill was enacted, that would actually happen.
Well, I think you'd extrapolate it the opposite way, and you'd probably see insurance premiums raised if these parts were not available to the marketplace.
I think that's a wonderful thing for these hearings is discussions and disagreements such as that. But in your written testimony, I do have an interesting question, and I'm going to sort of finish up here because, like I said, I think the chairman and Ms. Lofgren, who I have the greatest respect for, there is some ideas here that we could work for. But in your written testimony, you make a comment, and it's on page 3 of your written testimony. It says, not only do customers have the right to competition, they both have the right to safe and high-quality competitive parts. I'm just curious, where are you getting a right to competition?
Well, I think that's a fundamental right of the American capitalistic marketplace that has caused consumers great benefit over the years, and taking away competition from the consumer is un-American.
Well, I mean, we can debate American or un-American, but really when you say a right, you're implying almost a legal concept here. And I think that's an interesting way to hyperbole to put that.
I'm implying a fundamental right to choice, a fundamental right to options in the marketplace, and that fundamental right is also one of the biggest benefits that corporate America experiences when they offer us different products.
So conversely, for someone such as myself who believes that a strong and robust patent system actually encourages creation and not discourages creation, would you agree with me that patent owners have a right to enforce their patents?
They have a right to enforce those patents when those patents are legitimate. But in the case of this particular situation, I would like your opinion as to why all of a sudden all of these parts are patentable when 10 years ago they weren't.
Were they patentable 10 years ago?
Look at the list.
They were. They chose not
and
to.
they chose not to patent them.
And
So
again,
why are they choosing to patent them today? They're choosing them to patent them today because that's a way to limit competition.
so as a conservative who believes in free markets, you're going to run to the government to say, government, put your thumb on the scale. Mr. Gillis, I think that's a problem. And you make a business choice either way. I believe this bill has merit. I believe there's some things that we can work on to move forward on this. But frankly, there is some concern here when you distinguish patents and you do this in such a way that you do it, as you said before, it's all about money. There's also rights of the patent holders and the protections we look forward to. So I look forward to continued discussion. I appreciate you, Chairman.
Would the gentleman yield for,
Always.
I know you have to go, but before you go, I'll just mention, for example, those two fenders that are down front. We brought them in for a reason. One's live, one's Memorex. Unless you look at the label, you probably won't notice the difference.
Can I get one from a Honda?
Yeah, absolutely, absolutely. The gentlelady from Louisiana can help you.
Speaking of which, by the way, thank you for being here. You're one who, I always enjoy these panels, and when you have actually someone here who does the business every day, the one who gets up and writes the payroll checks and comes here. I love the other test witnesses, but when you got somebody like yourself, we may disagree in parts on this, but thank you for actually keeping America's economy running. Thank you.
Thank you.
But one of the things that we're going to dig into as we go further into the bill is that were these thousands, tens of thousands of design patents evaluated based on not the ornamental entirety, but the ornamental pieces, then the rules of distinct ornamental nature would have to be searched by the PTO, by the examiners. And this is one of the tests they currently don't do. In other words, when a certain car looks a lot like another car, and then a particular part looks a whole lot like another part, at what point is it novel and new? And this is one of the challenges of this legislation is designed not to take on the hard part of making the patent office evaluate the distinct nature of a mere or other parts. So we'll get into more of it, but I wanted to make sure that your concerns were allayed, that we're not planning on.
Well, and I think the chairman brings up a great point. If you really want to get into the overall patent issue, which you and I have talked about many times, we have to have good, robust patent systems that are actually examined. The problem we have right now is patents that can be challenged because they, frankly, are bogus patents, and that goes across the spectrum. You brought up a great point, Mr. Chairman. That's the reason we have this, and it's a pleasure to be on the committee with you.
Thank you.
Excuse me, Mr. Chairman.
Well, I apologize, but that colloquy exceeds by far the ranking member's time. So we'll give you time, but not at this moment. Mr. Conyers.
Thank you, Mr. Chairman. First, I'd like to enter into the record the following two letters. One's from original equipment manufacturers, labor unions, automotive trade associations, and the Intellectual Property Owners Association opposing this legislation. The other is a letter from the American Bar Association IP Law Section.
Without objection, and if I would stop the clock. I apologize. The gentleman has to leave. I just wanted to let him, if he had anything to say, since he's been very patient.
Absolutely.
If you have something, I didn't mean to cut you off.
No, not at all, Mr. Chairman. Actually, I have a family medical emergency, and I have to fly home. And so if it's okay, I would like to.
Well,
excuse myself.
you and your family will be on our prayers, and thank you very much for being here
Thank you very
today.
much. Thank you very much.
Thank you.
Quite all right. Thank you. Could I ask Attorney Burris about the ability to receive patent protection for an invention encourages innovation. It provides an incentive to create new products or improve upon other products. How would this legislation, in your view, affect creativity and innovation?
Well, I think it would significantly dampen that creativity. I mean, there's no incentive to create an invention, whether it be a design patent or utility patent or a plant patent under our systems, Where's the motivation to develop new technology, to advance that technology? I think I put a quote from Abraham Lincoln in my written statement. I mean, it is a fuel that provides incentive to develop new designs, new technology in our country and in countries around the world.
And thank you. And how, Attorney Burris, would it impact jobs in the automotive manufacturing industry?
Yeah, thank you. I talked a little bit earlier about the design centers in the United States. Industrial design is a little different beast than the traditional engineering that we're used to with mechanical, electrical, chemical, et cetera. They're very creative artist type engineers, and there are in the automotive industry approximately 30,000 industrial designers that are working on, you know, the shape of your door handle on your car, the shape and the colors and the texturing of your side view mirrors. And there's not just one designer working on a car. There may be 4 designers working on just the handle. I mean, I see it. I go to the auto show every year, and I see these really sharp-looking designs on these cars, and those I know are products of industrial designers. So jobs in the United States, not just U.S. companies, but foreign, Honda, Toyota, just in my home state, Toyota and Hyundai put in research centers right between Ann Arbor and Detroit. These are industrial designers developing eye-pleasing cars for U.S. consumers. So 30,000.
Thanks so much. What do you think, if this legislation were to pass, other industries would request similar legislation to shorten patent protections?
Well, you name it. Mr. Gillis might have that answer for us on what's more expensive. That shouldn't be too expensive. Smartphones? Consumer apparel? I mean, look at the companies who get design patent protection. You know, you have the Hewlett-Packards and the shape of a printer, for example, the Nikes, the Apples, the Samsungs. It could go on and on forever.
Now, supporters of this bill might argue that these are just patents on the look and style of the exterior car parts, so they do not need usual patent term protections. Do you think they're correct?
Well, there are laws. Our laws provide, well, it's actually now 15 years since we've signed up to The Hague, but our design patent protection is 15 years from the date of issue of that patent versus utility patents, which is 20 years from the date of filing the patent application. So there is a different patent term depending on whether it's a design or a utility patent.
Let's see, Mr. Risley's left. Let's see, Mr. Gillis. I'm concerned that the consumer safety could be threatened if this legislation were to pass. Do we have federal laws in place that would ensure that replacement parts from independent vendors or overseas vendors would meet the high safety standards that we would place on automobile manufacturers here in the United States?
Well, thank you, Representative Conyers. As you well know, I am one of America's leading auto safety advocates, and this is of great concern to me. The good news is that all of these parts are subject to the same recall requirements that car company brand parts would be subject to. In addition, with the concept of reverse engineering, it is relatively straightforward to make a part that is functionally equivalent to the car company parts. And finally, the industry that's probably most concerned about auto safety is the insurance industry, not only because they may be good guys, but because it's in their best interests to keep personal injury claims down. And as a result, they created the Insurance Institute for Highway Safety, which has tested parts that have been certified to be the same, and they perform the same in both low-speed and high-speed crash tests. So I don't think Representative, you have to be concerned about the safety issue as long as the manufacturer has been certified to be the same as the car company brand part.
Thank you very much, Mr. Chairman. I yield back.
Thank you. And we'll now go to the gentlelady from California, Ms. Chu.
Thank you. Ms. Felder, I understand that there's been an uptick in the number of design patents that the auto industries have filed over the years. In addition, companies like Ford began filing infringement complaints at the International Trade Commission. The complaints were filed against aftermarket suppliers of collision repair parts for popular and iconic cars like the F-150 and the Mustang. What are the outcomes of these cases, and how have they affected the overall market? Is it more difficult to find aftermarket parts for these cars today compared to years past?
Are we talking about the settlement cases?
Yes.
Yes, okay. The terms of the infringement patent suits settlement has made the parts in question more expensive, since only one aftermarket distributor in the country has the exclusive right to sell these aftermarket parts. They are paying royalties in order to be able to do so. That cost is passed on to the consumer. It is not absorbed by the distributor. That in turn is creating a problem for the repair industry. We are not allowed to supply these parts. We would be sued for infringement if we were to buy the parts from Ford, Chrysler, and now General Motors. Of course, our contention is this is indeed a slippery slope. Pretty soon we will not be able to do it for Toyota or Honda or any of the other parts that are made. So consequently, by allowing this patent situation to continue, we know that it has significantly diminished the competition and has created a duopoly.
And you have stated that your own company received cease and desist letters from a number of car companies who warned you of your infringement liability risk if you continue with your business. How did you react when you received these warnings, and what are you doing to address them?
The distributor that has the exclusive licensing agreement is allowed to resell those parts. We do not prefer to buy them because there is no economic incentive to do so. By the time we purchase the parts for the price that we have to pay, put them in a truck, get them to the customer, we often have lost money. We've done it because we have certain customers that have asked us to do it. They know it's going to cost a little more. We have to at least try to cover the cost of doing so, but we prefer not to sell these parts. We have received a letter from Chrysler saying that we had a cease and desist letter. It cost us over $3,000 to hire a patent attorney to answer this letter and state we were purchasing the parts from the licensed distributor who had the right to sell those parts to us. They didn't just take our word for it, so we had to go to the expense of paying a patent attorney to represent us in this case.
Okay. Thank you. And Mr. Gillis, you're urging Congress to address the automakers' misuse of design patents on their crash replacement parts. Can you explain how you believe design patents are being misused by the auto industry?
Well, first and foremost, I think the evidence is in this chart over to my left. All of a sudden, in an effort to disrupt the competitive marketplace, the car companies are starting to put design patents on these individual parts. There's nothing more special about these parts today than 15 years ago. But they've taken on the design issue or design patent issue as a business strategy rather than a legitimate means to protect the design of an individual part. The second issue is that by putting these patents on individual parts, they are preventing me as a consumer from having a variety of choices when I go out to get my car repaired. As I said in my testimony, I bought the car. I didn't necessarily want to become an indentured buyer to the car company for the rest of that car's life. I want choice.
Thank you. Well, if I could have Ms. Burris respond to the same thing?
Of course.
Sure, about the rise in the number of design patents?
Well, this claim that design patents are being misused.
Right. Well, I mean, under our patent laws, our design patents cover an ornamental article of manufacture. So that's in our laws, and anyone who applies for a design patent is entitled to protection, provided it meets the requirements at the Patent Office. I think a couple of things are going on with the rise in the number of patents that you see, design patents. I think that number one, first of all, the parts aren't the same as they were 15 years ago. They're much more advanced technologically with new materials, with integration with other sensor systems in the car, and the styling of the cars is much more attractive than it used to be 15 years ago. I think that offshore companies are able to make those parts very quickly with digital scanning technologies. They don't have to cut a tool or a mold. They scan the part. They've got a tool automatically, and they can chunk out parts very quickly. So I think there came in this influx, which is why it went to the ITC, of parts that were basically copied. So that was a response to, I think in part, response to the influx of parts that were being copied overseas. Secondly, and I'm actually going to do this when I get back home when I have time, design patents overall have taken off. They really have shot up at a much higher rate than they have in the past overall. And there are statistics at the Patent Office that you can see. And I think ever since that Apple-Samsung case, design patents they're kind of in vogue right now. A lot of people are filing more and more design patents, and it's not just the automotive companies.
Thank you. I yield back.
Thank you. We'll now go to the gentleman from New York. I'm gonna do cleanup, so hang around though.
All right, thank you, Mr. Chair. And let me just thank the witnesses for their presence here today. Ms. Burris, you're opposed to this legislation, correct?
That's correct.
And is your opposition anchored in large part to your view that there should be uniformity across the patent law system that we have in this country?
Yeah, my primary objection is this carve-out, this exception for automotive repair parts, and where might that lead us after this? What else might be too expensive for the consumers? There's got to be another way to fix this.
Now, is there any precedent for this type of carve-out as it relates to intellectual property law, as you understand it?
In the United States?
Yes.
Outside of pharmaceuticals and generics, I'm not aware of any. There's certainly not any in the design patent world.
Now, is there any concerns that you have as it relates to taking this approach in the automobile parts space?
Well, absolutely. As I mentioned earlier, the shape, the look of the car has been, the car companies have spent a lot of money with their industrial designers to come up with that eye-pleasing design, and now we're going to say, well, no, we're not going to allow you any protection on that. There's a lot of effort that goes into these quote, repair parts. It's more than that.
And with respect to the legislation's broad applicability, it's my understanding that this would be retroactive. Is that correct?
That's my read, yes.
And so that means that it would apply to patents that have already been issued?
Correct. So yes.
As well as applications that are pending?
Correct.
Could you just speak for a moment to the issue of the equity in sort of retroactively changing the length of time of a patent from, I guess, what would be 15 years down to 30 months? Someone
sure.
who already had a reasonable expectation based on existing law at the time of them getting the patent or filing the application.
Sure. I mean, when a patent applicant filed their application 5 years ago, the bargain was, that's the quid pro quo. I'm going to disclose my design in return for a 14-year, which is now a 15-year term. That's what you bargained for when you filed that patent application. That application that was filed 5 years ago, if this bill were to go through, would be expired if it were repaired. It would just be gone. It would evaporate.
And do you have a sense of whether there would be any sort of Fifth Amendment takings concerns in connection with retroactive application?
Actually, I had not really thought about that.
Okay. If you have any thoughts subsequent to this hearing, I'd be interested in you sharing those with me and or the committee. Mr. Gillis, it's my understanding that you believe, were this legislation to be enacted, that the cost savings that it would yield would inure to the benefits of the consumer. Is that correct?
That is correct, yes.
And so you don't believe that the purported cost savings that would take place wouldn't result in either the aftermarket car manufacturers yielding any additional profits, or the insurance companies yielding those additional profits? It's your contention that the savings would be passed to the consumer, is that right?
Well, first of all, it's important to note that the parts are here today, and consumers are benefiting from those parts being in the marketplace, and they're benefiting in two ways. They have access to less expensive parts, plus their very existence keeps the cost of the car company part in check. When you pull these parts out of the marketplace, there will be no reason for the car companies to keep their prices low. They will have a monopoly, and they can charge anything they want for those prices. So thankfully, the parts are here, and thankfully consumers are benefiting from those parts. The problem with these patent laws is that they are now taking these parts out of the marketplace, and that's what's going to hurt consumers.
Okay, now, if this legislation were to pass, would the insurance companies likely see an increase in their profit margin, separate and apart from the question of whether that thing gets passed along to the consumer, but are they likely to see an increase in their profit margin?
Right now, probably there are few industries that are more competitive than the insurance industry. We consumers are shopping around like crazy for insurance policies. So if the insurance companies can keep their policy prices in check, they're going to be very happy to be able to do that. And if they can lower their prices, they certainly will, because that's the way we are buying insurance these days, if you see any of the ads on TV about which insurance company is the least expensive. So conversely, however, if these parts are pulled out of the marketplace, you're going to see substantial increases in the cost of getting cars repaired, and that cost will be simply passed right on to us, either in higher insurance premiums, or if we do not have adequate insurance, out of our own pockets.
Thank you. I yield back.
Thank you. I'm going to try and get through a lot of questions quickly. Ms. Burris, I'm going to go through a couple with you because you made some interesting points, and I want to make sure we get them in the record. First of all, you made the point about 30 months not necessarily being 30 months. If it was 30 months from the first sale, would that make a difference to you in the legislation, since you said they wouldn't get 30 months? If they got 30 months, in other words, from first sale, would that matter to you?
No.
Okay, so the fact that it's not, your concern is you want 14 years, is that correct?
Yeah, that's what the law says.
Well, that's what
15
Congress
now,
made
actually.
it.
Yeah.
Okay, how long is the patent on address?
Pardon me?
How long is a patent on address?
How long?
If a designer does a gown,
Sure.
how long is the patent?
It's 15 years from the date of issue. If it's filed on or after May 13th of 2015, it's now 15 years under the Hague Agreement.
And that is something the United States didn't have. We tried to have design legislation for dresses for years, right?
I'm not familiar with the years of legislation on dresses, no.
Okay.
Sorry, I'm sorry.
The gentleman who once sat right here, Mr. Berman, and I co-authored a bill to actually create a patent for designers, which they had in Europe and we didn't. So let me get through a couple of quick questions. First of all, if we made it 14 years, you'd be happy, is that right?
The law, the design patent law.
No, just answer the question, because you are here representing companies. You've talked about a lot beyond the scope of patents. You've talked about the auto companies.
I also have an engineering background as well.
But you've included a lot of material that clearly came outside of patent law. Would you be happy with 14 years exclusivity?
I would be happy with the term that the design patent laws provide.
The current
today.
law.
The current law is now actually now 15, but 14, yeah, it's
Okay.
15 under the Hague.
Okay. But you're not happy with 30 months?
No.
Okay, so we're arguing over your level of happiness based on length. Let's go through a few of these points. What about the fact that auto companies change their designs? And they change them arbitrarily for design reasons. Do you think a patent should go on even though the car is out of production? They are no longer making that vehicle. Do you think that should trigger any change in it?
No.
Okay. Is there anything that would cause you not simply to want greater exclusivity for the auto manufacturer?
I am sticking to the language of the design patent laws. The 15 years is what we should.
No, ma'am, I appreciate that, but I just want to know if if your position is that you like the fact that as the auto companies are currently pushing the law through litigation, and particularly through the International Trade Commission, which is not an Article III court, they are trying to gain exclusivity for 15 years for each and every part of an automobile. And as they're increasing that and suing to get it, you're fine with that, right?
I do believe a patent owner should be entitled to enforce their patent, yes.
Okay, well, let's go through a fairly straightforward thing. Ms. Felder, you're an expert in the auto parts industry. You know about fenders and bumpers and so on. And you've got really good people, I'm sure, in your company that deliver those parts, right?
Yes, sir.
How often do they confuse the wrong part if they don't check the number closely? Because these fenders all look alike, and a lot of these parts look alike, right?
No, Mr. Chairman, they do not. The parts, when you bring them, are quite obviously, if they're wrong, it's very easy to see. We have two fenders here. If I brought in, these fenders are for a Malibu. If I were to bring in a fender for a Honda, you would be able to put it up and say, this is not the same fender.
Yeah, but that's not the standard for a design patent. Ms. Burris, I'm sorry. You have two patents in front of you. Looking at the siren patent that's in front of you, the one on the right, does it look like a siren?
Well, the title says siren, so yes,
Okay,
now I look
that's
at it,
speaking.
now it looks like a siren.
Okay.
Honestly, when I looked at this side, I wondered if it was an ice cream maker, but maybe because it's getting late in the day.
Now, there's a limitation on what that patent means under the law, right? The law that you were so pleased with, as it currently is, there is a limitation on that patent. What is the limitation of the patent? What does somebody get if they apply for that patent and receive it in 1994?
This design patent covers the ornamental appearance of this article of manufacture at this time 14 years from the date it issued.
Right, from date of issue of the old law. And so that is a exclusivity in its entirety, correct?
What do you mean by in its
If
entirety?
it's substantially different but looks similar, it's still not, it's not patented, right?
I'm not sure I follow your question. You're talking about someone who might be trying to design around this patent?
Yeah, exactly. Somebody,
Yeah,
somebody can make an extremely similar product. As a matter of fact, that is similar to the sirens manufactured by every single auto security company and home security company in the world in that period of time. They pretty much all look the same. So what you really had there was a very narrow patent. Is that correct?
I can't say how narrow it is, not knowing the prior art. I mean, there's some prior art listed here on the front, but I'd have to take a closer look to see how broad or narrow it would be.
Okay. Well, this brings up the point. What should be the standard, if not this legislation, which gives absolute exclusivity and does not raise the test for these parts? What should be the test when a fender is basically very similar to a previous fender? In other words, if you have nothing, and I'll go to Mr. Gillis because I've left him out, if the auto companies are in fact consistently adding a line, taking away a line, putting in a line, making a change, making it rounder, making it squarer, at what point should the Patent Office look back 50 years, even 100 years, because the auto industry is now over 100 years old, and hold them to a high standard of whether or not the ornateness of that sub-part of an automobile, not the entire automobile, but that sub-part is in fact de minimis over the prior art and thus not worthy of a design patent?
Well, Congressman, you know that our position actually is from day one. They should not be allowed to put design patents on these individual items. If it's wrong after 30 days, or if it's correct after 30 months plus one, it should be correct after plus one. So I think that where you're going with this is, number one, we fully respect the design of the car should not be tampered with. And Ford should not be able to copy Chevy's car at all. Nor should Ford be able to build parts to copy a Chevrolet. The beauty of your legislation is that we call it a repair clause. These parts are designed to be repaired, to allow the consumer to repair the car, not build a new car or make it look like the original car, but to repair their own car. And we need the freedom to be able to buy these parts unencumbered at a reasonable price. So if the manufacturer wants to hold these designs for 14 years, and as you suggest, then the next year slightly put another wave in it, then they get another 14 years and another 14 years on top of that, again, we see that as an illicit use of very important design patent laws.
Ms. Burris, you're not as old as I am, so I'm going to ask, are you familiar with the history of Xerox and other photocopy companies who have tried to design their products to prohibit people from essentially making the consumable parts that go into them?
Oh, yes, I'm very familiar with consumable part protection, yes, for not just Xerox, for other industries as well.
So the ability to have, if you will, quiet enjoyment of something you paid for, which includes the ability to, if you will, get toner with competition, you're familiar with that and you're comfortable with that, is that right?
Well, they spent a lot of money designing a product that they had patent protection on. They should be able to enforce.
But they don't get
patents.
design patent protection. They only get utility to the extent that they have.
Yeah, I'm not familiar with their patent portfolio.
Well, you're familiar that there are aftermarket products
Sure.
available for your copy machine and
Sure, you
so
can,
on.
you can always design around a patent. You can always get, it's just, how much more expensive is it going to be? Is it going to perform the same way? But you can, even design patents, you can design around them.
But sure, you can always make a fender that doesn't match the other fender,
You mean the front and the back?
the left and the right.
Or the quarter panels?
Right. Not very desirable. First sale concept, Mr. Gillis, your position, I assume, is that even though we're trying to find legislation that accommodates middle ground, that in fact when you purchase something and you get a ding in it and you have a choice of pound it out, put some Bondo in it and hope for the best, or replace it, that you should be able to buy a replacement part from anywhere you want, since it's only a subcomponent of that patented or unpatented product that you bought and paid for. Is that right?
That's exactly right, and the best evidence of that, Congressman, is who among us, after our warranties expired, is going to go back to Ford to buy a battery, to buy a muffler, very important and sophisticated parts of the car, or to buy a tire? We like that freedom in mechanical parts, which are probably far more important to the safety of the vehicle than exterior cosmetic parts, so we just want that same freedom when it comes to exterior cosmetic parts.
And your point being that if I want to put a new manifold on, they're not bothering to patent that under design patent, and yet they do want to have the part that gets hit in a fender bender.
That's right, and in fact, Ms. Burris alludes to the concept of utility patents in her presentation, her written presentation, and our theory is if the hood has certain waves in it that are of a utility function, then they should get a utility patent, and that's perfectly fine. But what we're talking about is design patents for very important functional parts.
Ms. Felder, the chairman has indicated in his opening statement, I know you didn't get to hear him present it, but that he's open and he wants to continue with this legislation and begin, finding, if you will, legitimate concerns and seeing if we can't address them. Let me ask a question for you, and this is a question from one former business person to a current businesswoman. One of the things you mentioned in these exclusive settlements is, in fact, that you cannot produce or find a producer of a product, even if they're QS 9000, ISO qualified, they're making a certified part. The fact is they can't get a license from the auto company, but somebody did, right? So as a businesswoman, if the auto companies, like the music producers and so on, had a compulsory license where they had to allow anyone to get a license to use, if you will, would that be something where at least you would see an even playing field where you pay the $2.50 for the license on the fender, but competition can find 10 different people to produce a product and have real competition on how it's distributed and how it gets to you and whether it's competitive? This is a business question,
Right,
not would we love to have $2.50 in licensing fees in a product.
Our concern, of course, is, again, restriction of competition. in a free market, which is what our country has been based on, we should not have to go and pay a licensing fee to provide a customer with a competitive product. There are many instances where I'm sure that might be an appropriate situation. In my opinion, this is not one of them.
Okay, and I apologize, but
Everyone-
there's a vote on the floor, so I still have to answer the bell. So if you can wrap it up, please.
That, very briefly, I want to explain that over the course of the time between the patent legislation, the patents were enforced, 2007, we have seen this industry literally almost erased. In our state alone, there were 5 independent distributors. Today, we are the only man standing. And this is national.
Thank
And
you.
this is as a result.
Mr. Gillis, I'll let you do the close. Right to repair. It's talked about a lot. It's gaining speed around the world. Notwithstanding questions as to patents, both utility and design, do you believe that it should be an open market for quality certified products to be able to have access to licensing fees so as to provide a real market and not a monopoly?
Well, right to repair is critically important, and it's become more important as automobiles have become more sophisticated, and the car companies tend to be closing up the ability of independent repairers to be able to get the computer diagnostic materials, the parts, even the tools in some cases to repair those cars. So it's clear that the fender, hood, and grill issue is just the beginning of the car companies wanting complete vertical integration over the control of this particular part, and that's bad for consumers.
Well, there'll be more to follow. I would encourage all of you to, if you will, revise and extend if you have thoughts on things that weren't asked and you'd like to submit them. My expectation is the chairman and I will work on future hearings, including with the Patent and Trademark Office. I want to thank you for your kindness in waiting for a little later time today. That helped a great many of us work around our schedule. And with that, the hearing stands adjourned.